Hello friends, welcome back to the series of lecture. This is the 23rd lecture of this series of CPC. And in the res judicata, we are seeing whether the res judicata would apply in appeal or not. And that in previous lecture we had left on the sheodan Singh case. We have seen some part of this sheodan Singh case versus Srimati Darya Kumar 1966 Supreme Court. Wangchu Justice, 4 judges bench. So suppose this is the family tree of that family. F, Fs, HS, F double S and F triple S. F triple S is the applicant and F double S is the father of the applicant. Of F triple S is Sheodan Singh and F double S is his father, and HS is the uncle of F double S, that is Harman Singh. W1 is widow, her widow, and RK is the adopted son. Ramkishan is the adopted son of Harman Singh, and DK is Darya Kumar is the widow of Ramkishan. Of the suit filed by FSS, the suit filed by FSS along FSS, FSS के मरने के बाद this person is the party. So FSS against, there are two suits filed by them. There are two suits filed by them against W1. There are two suits filed. Then there are two suits filed by W, widow of Darya Ramkishan. Darya Kumar filed two suits against FSS. So there are 4 suits in total, and all these suits are decided after the consolidation. They all are consolidated by the court, and they were decided against Sheodan Singh. Now there are 4 decrees in a judgment. 4 decree 1, decree 2, decree 3 and decree 4, which are all against Sheodan Singh, and therefore Sheodan Singh has the appeal against all the 4 decrees. There were 4 appeals, 1, 2, 3, 4. There were 4 appeals, and they were all filed by the Sheodan Singh against the decrees, and out of which 2 appeals were dismissed. Out of 4, 2 appeals were dismissed, and the dismissal was on technical ground. One appeal was dismissed because of the bar of limitation. एक अपील तो dismiss हुआ because of the bar of the limitation, and the other appeal was dismissed because of the non-prosecution. Some documents were required that was not given because of non-prosecution. The point is, these 2 appeals which are dismissed on technical grounds. So will the other 2 appeals also be dismissed on the ground of res judicata, or can the court continue hearing on these 2 remaining appeals? तो ये क्वेश्चन था बिफोर द कोर्ट. अब आप इसके लिए ये वाला पैराग्राफ पढ़िए. The appellant's father was aggrieved by this decree. He is appellant's father. The appellant's father was aggrieved by these decrees. Consequently, he filed 2 first appeals in the High Court. Appeal number 365 was against the dismissal of suit number 37, while appeal number 366 was against the dismissal of suit number 42. The appellant's father also filed 2 appeals in the court of the district judge against the judgments and decrees in the suit filed by the respondent. Srimati Darya Kumar, appeal number 452 was against the decree in suit number 77, while appeal number 453 was against the decree in suit number 91. So overall these are the 4 appeals. अब नंबर से हमको क्या लेना? You have to understand that there are 4 appeals. Then thereafter appeal number 453 arising out of suit number 91 was dismissed by the High Court as being time barred, while appeal number 452 arising out of the suit number 77 was dismissed by the High Court on the ground of failure of appellant's father to apply for translation and printing of the record as required by the rules of the High Court. It may be mentioned that the appeals number 452 and 453 were given different numbers on transfer to the High Court. So after appeal number 452 and 453 out of 4 is dismissed. Were dismissed. अब इधर से आगे पढ़ो. After appeals number 452 and 453 has been dismissed, an application was made on behalf of the respondent Srimati Darya Kumar, praying that first appeals number 365 and 366 be dismissed. So that is the technical point. So she is praying that the other two appeals should also be dismissed. Now as the main question involved therein, namely title of Srimati Darya Kumar to the suit property, had become final on account of the dismissal of the appeals arising out of the suit number 77 and 91, when the question came up for hearing before a learned single judge of High Court, the following question, namely whether the appeal is barred by section 11 of the Code of CPC or Code of Civil Procedure or by the general principles of res judicata, as the appeals against the decision of suits number 77 and 91 were rejected and dismissed by this court, and those decisions have become final and binding between the parties. Was referred to a full bench for decision in view of some conflict between two division benches of that court. अब देखो क्वेश्चन क्या है कोर्ट के पास. अब देखो यहाँ पर देयर आर 4 अपील्स आउट ऑफ विच 2 आर डिसमिस्ड. अब देखो यहाँ पर तो देयर आर 4 अपील्स, बट इसको सिंप्लीफाई करके हम 2 अपील की बात करते हैं. सपोज देयर वाज अ सूट बिटवीन A वर्सेस B. देयर आर 2 सूट्स, A versus B and A versus B, and they were consolidated and the decree is passed. So there are 2 decrees. Decree 1 and decree 2. अब suppose in both the decrees A is the aggrieved party. Suppose अब A ने B के खिलाफ अपील किया डिक्री 1 में और A ने B के खिलाफ अपील किया डिक्री नंबर 2 में भी. ठीक. अब suppose one appeal was dismissed on some technical ground. Suppose on the bar of limitation. One appeal is dismissed on some technical ground. The question is, if one appeal has been dismissed. So if one appeal has been dismissed, अब दूसरा एक और appeal है which is pending. Appeal 2. Appeal 2 is pending. One appeal was dismissed by court on some technical grounds. The question before the court is that the 2 appeals arise out of the same suit. Same suit मतलब same judgment, 2 decrees, and filed by the same party. One appeal is dismissed on a technical ground. So will that result into a res judicata on the other appeal, or will the other appeal also be dismissed? So that was the question before the court. अब देखो अगर merits पे decide हुआ then always the res judicata will apply. But here the question is that the earlier appeal was dismissed on the technical ground and the other appeal is pending, and the appeal is basically with respect to the same title to the property. So the subject matter, the matter in issue of the 2 appeals be the same. Broadly, substantially, the matter in issue of the 2 appeals are the same. Parties are also the same. दोनों में A and B है. ठीक. Parties are the same. The matter in issue is the same. Then title is the same. अब main issue क्या है? 2 issues हैं. One, as to whether the appeal which has been dismissed on the technical ground can be said to be a separate suit, because former suit and subsequent suit we read, जब तक former suit dismiss नहीं हुआ है तब तक subsequent suit में former suit नहीं आएगा. अब ये जो अपील डिसमिस हुआ है क्या आप इसको former suit मानोगे? So that is one question. Can this considered to be a former suit? और दूसरा जो इशू है that the former suit should have been decided on merits, that is it should have been heard and finally decided. So दूसरा इशू है that can the former suit or a former appeal is said to have been heard and finally decided by the appellate court. अब here if it was decided on merits तब तो प्रॉब्लम नहीं थी, but here it is a dismissal on technical grounds. तो जो टेक्निकल ग्राउंड्स पर डिसमिस किया है, तो कैन यू से दैट द सूट वाज हर्ड एंड फाइनली डिसाइडेड? तो पहली बात तो कैन यू से टॉक अबाउट द फॉर्मर अपील अ फॉर्मर सूट? नंबर 1, you talk about the former appeal of former suit, and number 2, can you say even though it was dismissed on a technical ground, it was heard and finally decided? So these are the two issues before the court. अब इसमें parties same है, matter and issue are the same, all things are same, so on these points there is no controversy, but the controversy was on the point regarding these 2 points. ठीक, तो इशू समझ में आया आपको? ठीक, तो अब इस केस में 4 अपील्स थे, बट उससे कुछ फर्क नहीं पड़ता। तो 4 अपील्स में से 2 अपील डिसमिस हो गए, एक तो लिमिटेशन के ग्राउंड पर डिसमिस हो गया और एक अपील लैक ऑफ प्रोसिक्यूशन के ग्राउंड पर डिसमिस हो गया। सो द 2 अपील्स वर डिसमिस्ड एंड 2 अदर अपील्स आर पेंडिंग. अब द 2 अदर अपील्स will amount to 2 dismissed appeal will amount to res judicata upon the 2 pending appeals. So that is the question. And other all elements are fulfilled. Now here the only examination is, so when all the other elements are fulfilled, here the only examination is the 2 appeals which are dismissed can be act as a former suit for the purpose of section 11. Means what? Do they have the distinct identity? And number 2, can it be said that they are heard and finally decided? अब ये जो आपका फॉर्मर सूट वाला जो कॉन्सेप्ट है ये समझा रहा हूँ, वैसे तो हमको सब पढ़ के समझना है, बट बिफोर को ऐड, अब फॉर्मर सूट का क्या मतलब है कि प्रेजेंट सूट और फॉर्मर सूट दोनों की आइडेंटिटी अलग अलग थी, तभी तो आप उसको फॉर्मर सूट मानोगे. अब यू हैव टू सी दैट देयर वर 4 सूट्स एंड एवरी सूट हैज अ डिग्री. जजमेंट सिंगल था, ट्रायल कॉमन था, लेकिन डिग्री 4 हैं और उनका सूट नंबर, ओरिजिनल सूट नंबर भी अलग अलग है, 97, 91, 92, all those. So the suit numbering are also the different. तो अलग आइडेंटिटी है, 77, 91, 92, etc. So do these suits have the distinct identity each? क्या हर सूट को आप डिस्टिंक्ट आइडेंटिटी वाला सूट मानोगे? अब ये सारे के सारे सूट्स अलग अलग फाइल हुए थे, कोर्ट के कन्वीनियंस के लिए कंसोलिडेट कर लिया इनको, फिर भी डिग्री तो 4 अलग अलग पास होंगी, एंड देयरफॉर ईच ऑफ दिस सूट हैज डिस्टिंक्ट आइडेंटिटी even though they are consolidated. There are 4 decrees and each of the appeal, therefore appeal relates, because appeal relates to the suit, so each of the appeal therefore will having a distinct identity because the original suit has distinct identity. Original suits have distinct identities, so appeals in the also have distinct identities, and therefore since these 4 appeals have since having the distinct identities, so each of them can be seen an independent appeal with respect to the other. Of the 2 appeals which has been dismissed, these 2 appeals can be said to be former suit for the purpose of section 11. जब आप सिंगल सूट से कोई अपील करते हो, ध्यान देना, उस पर भी एक केस है हरी वर्सेस शंकर, आई वुड डिस्कस दैट लेटर ऑन. तो उसमें अगर सिंगल सूट से अपील किया आपने, ओरिजिनल सूट जो था वो सिंगल सूट था और उससे 2 अपील किया आपने, then it will not having the distinct identities. ठीक, because the original identity was the same. तो in Narhari versus Shankar they are talking about this कि अगर एक सिंगल सूट था और उससे 2 अपील्स हुए, so these appeals cannot be considered to be a having distinct identities. But if you are having original several suits and from each suit you are going in appeal, then every appeal has got distinct identity. So that is the difference between the that is the difference between that is the difference between the facts of शेदान सिंह एंड नरहरि वर्सेस शंकर. तो उस पे तो आएंगे अभी बाद में. वी आर रीडिंग इट. तो देयरफॉर जो पहला जो पॉइंट है आपका फॉर्मर सूट, so the requirement of former suit is fulfilled because these appeals have originated from independent suits and every suit has its own independent identity. ठीक. अब इसको अब मेरे शब्दों में लिख लीजिए आप. बाकी की जब आप पढ़ोगे तो उसको आप ऐड ऑन कर लेना. So right, the main issue in the case was as to whether upon the dismissal of two appeals on technical grounds it will amount to res judicata upon the two pending appeals. The issues were mainly two. The issues were mainly two. अब उसमें और भी इशूज थे बट मेनली हमारे कॉन्टेक्स्ट में दो इशूज हैं. द इशूज वर मेनली टू. नंबर वन whether the dismissed appeals can be considered to be a former suit with respect to the other two pending appeals in the context of section 11. ठीक. अब इसका एक छोटा सा आंसर लिख लो आप. राइट. The main test given by the court was as to whether these appeals arose from such suits which had an independent identity at the trial stage. In the present case, there were two independent suits in the trial court, though they were all consolidated in a single trial. Each of these suits had their distinct identities and suit numbers. Moreover, 4 decrees out of the single judgment was passed, and each of the appeals was an appeal against each of these decrees. Thus, the identities of these appeals were different, and hence the dismissal of two appeals can be considered to be former suits decided. अब नेक्स्ट पैराग्राफ में लिखो. नेक्स्ट पैराग्राफ. Had there been a single suit at the trial stage, and from such suit various appeals were filed, then since these appeals arose from the same suit, they would not have distinct identities. Therefore, it cannot be said that they were distinct suit. It cannot be said that they were distinct suits. ठीक. It cannot be said that they were distinct suits. ठीक. तो ये फॉर्मर सूट का जो कॉन्सेप्ट वो नहीं लगेगा यहाँ पर अगर ट्रायल कोर्ट में सिंगल सूट होगा तो ये आपका पहला इशू था. अब इस पर थोड़ा सा रीडिंग कर लें, फिर सेकंड इशू पे बाद में आएंगे. अब आप ये वाला पैरा पढ़ो. The full bench came to conclusion that two matters were directly and substantially in issue in all the four suits. Number 1, whether Harnam Singh and his adopted son Ram Kishan died in a state of jointness with the appellant and his father. So that was one issue कि पार्टीशन के बाद मरे या पार्टीशन के पहले मरे. Then whether the property in the suit was joint family property of Ram Kishan and the appellant's father. ठीक. तो दो इश्यूज है ना. एक तो ये राम किशन और appellant फादर उन सब का जॉइंट प्रॉपर्टी था कि नहीं या फिर कहीं पार्टीशन हो गया था. And the decision of civil judge on both these issues was against the appellant and his father and in favor of Srimati Darya Kumar. The full bench held that though there were 4 appeals originally before the High Court, 2 of them been dismissed, and the very same issues which arose in the first appeal, number 365-366, had also arisen in these 2 appeals which had been dismissed. The full bench found further that the terms of Section 11 of Code of CPC, the Code of Civil Procedure, were fully applicable, and therefore the 2 appeals number 365 and 366 were barred by res judicata to the extent of the decision of 5 issues, which were common in 4 connected appeals. In the result, of full bench returned that answer to the question referred to it. In the result, the full bench returned that answer to the question referred to it. तो उनने भी मान लिया, full bench ने भी मान लिया that the suit is barred by, that the other appeals are barred by res judicata because all the elements of section 11 has been fulfilled. तो उन्होंने practically मान लिया that the appeal dismissed in the former suit, dismissed are the former suit, and they can be said to be heard and finally decided. And after this decision of the full bench, the matter went back to the learned single judge for decision, who thereupon dismissed the appeal as barred by section 11 of the Code of Civil Procedure. The appellant then obtained a special leave from this court, and that is how the matter came up before the Supreme Court. Before the full bench Supreme Court. So is that fine? तो उन्होंने ऑर्डर पास कर दिया, नीचे ट्रायल कोर्ट को दे दिया, ट्रायल कोर्ट ने जजमेंट पास कर दिया और उसको बार डिक्लेयर कर दिया बाय रेस जुडिकाटा, एंड देन द अपील फाइनली गोज टू द सुप्रीम कोर्ट. ठीक, अब देयर आफ्टर दे आर टॉकिंग अबाउट द सेक्शन 11 एंड सेक्शन 11 के एलिमेंट्स. तो इसको आप पढ़ लेना अपने आप. तो इट इज टॉकिंग अबाउट सेक्शन 11 एंड इट्स एलिमेंट. अब ये सेक्शन 11 में जो पॉइंट नंबर 5 है, इसको आप एक बार देख लीजिए. Point number 5. The matters directly and substantially in issue in the subsequent suit must have been heard and finally decided by the court in the first suit. तो जिस मैटर पे आप रेस जुडिकाटा लगाने की बात कर रहे हो, that matter directly and substantially in issue should have been heard and finally decided by the former court. Further explanation one shows that it is not the date on which the suit is filed that matter, but the date on which the suit is decided. So that even if a suit was filed later, it will be a former suit if it has been decided earlier. So that everyone knows. ये पहले भी पढ़ रखा है. तो जिसका decision पहले आया, that will be called a former suit. In order to therefore that the decision in the earlier 2 appeal dismissed by the High Court operates as res judicata, it will have to be seen whether all the 5 conditions mentioned above have been satisfied. तो वो सेक्शन 11 के कंडीशंस मैंने आपको बोला, टाइटल, मैटर इन इशू और पार्टीज. तो ये तो बिल्कुल क्लियरली प्रूव हो गए. अब इसके अलावा 2 और बच गए, हर्ड एंड फाइनली डिसाइडेड एंड फॉर्मर सूट. फॉर्मर सूट का भी दे हैव डिस्कस्ड. अब मेनली व्हाट इज लेफ्ट इज हर्ड एंड फाइनली डिसाइडेड. फॉर्मर सूट का भी हैव ऑलरेडी डिस्कस. अब देखना व्हाट इज मेंट बाय हर्ड एंड फाइनली डिसाइडेड. तो इसके बाद सो मेनली वी हैड सीन दैट व्हाट इज मेंट बाय हर्ड एंड फाइनली डिसाइडेड. अब इसके बाद अब ये बीच के पैराग्राफ आप पढ़ लीजिएगा अपने आप. अब ये वाला पैराग्राफ देखिए आप, रिलेटेड टू फॉर्मर सूट. Then it is urged that all the 4 suits were consolidated and decided on the same day by the same judgment, and there can therefore be no question that the suit number 77 and 91 were former suits, and thus the decision as to title in those suits become res judicata. It is not in dispute that the High Court's decision in the appeals arising from suit number 77 and 91 was earlier. Reliance in this connection is placed on the decision of this court in Narhari versus Shankar. Narhari versus Shankar 1950 का सुप्रीम कोर्ट का जजमेंट है. Narhari versus Shankar 1950. In this case, however, no application to facts of the present case because the suit was only one. Nahari versus Shankar में the suit was only one, and therefore that would not apply to the present case. So Nahari versus Shankar has no application to the facts of the present case because there the suit was only one, which was followed by two appeals. एक सिंगल सूट है, डिक्री आई, दो अपील फाइल हुई उसमें, it was followed by two appeals. The appeals were heard together and disposed by the same judgment. Those separate decrees were prepared. अब सूट के अंदर दो अपील हुए, दोनों को कंसोलिडेट करके अपलेट कोर्ट ने डिसाइड किया। अब क्योंकि दो अपील से दो डिक्री पास हुए, अब दो डिक्री होने से आइडेंटिटी, अपील में दो डिक्री होने से दो आइडेंटिटी अलग अलग नहीं हो जाएंगी, क्योंकि ओरिजिनल सूट कितने हैं वो देखा जाएगा। अपील में दो डिक्रीज हो गई, बट ओरिजिनल सूट कितने थे? देयर वाज वन ओनली. So each of these appeal arose from the same suit. The appeals were heard together and disposed of by the same judgment, though separate decrees were passed. An appeal was taken against one of the decrees. अब उसके बाद सेकंड अपील फाइल हुआ ऊपर, तो एक जो आपका सूट था उसमें वो अपील, डिक्री के बाद अपील, और वो भी डिसाइड हो गए। तो दो अपील हुई थी, उसमें से एक अपील डिसाइड हो गई, तो उस एक अपील के बाद एक और अपील, फर्दर अपील, सेकंड अपील फाइल हुआ। An appeal was taken against one of the decrees. In those circumstances, this court held that as there was only one suit, it was not necessary to file two separate appeals, and the fact that one of the appeals was time barred did not affect the maintainability of the other appeal, and the question of res judicata did not at all arise. अब दो अपील थी आपके पास, इट वॉज अ सिंगल सूट। अब उस सूट के खिलाफ मान लो दोनों पार्टी डिससेटिस्फाइड है, अब एक ने अपील किया और दूसरे ने भी अपील कर दिया, सेपरेट अपील। अब द रीजन इज आपको दोनों को अपील करने की जरूरत नहीं है, अगर एक भी अपील कर दे तो उस अपील के जवाब में क्रॉस ऑब्जेक्शन रेज कर दें। क्रॉस ऑब्जेक्शन में दूसरी पार्टी अपने पॉइंट्स रेज कर सकते हैं। सपोज ए एंड बी आर इनटू अ सूट वाज डिक्रीड इन फेवर ऑफ ए, but A was not satisfied by the decree and B was also not satisfied by the decree. अब A ने भी अपील कर दिया और B ने भी अपील कर दिया, तो ये ऑर्डर 41 में मिल जाएगा आपको। द रूल इज इट इज़ नॉट नेसेसरी कि दोनों पार्टी अपील करें। जब मान लो सिर्फ A ने अपील कर दिया, तो उस अपील के जवाब में B अपने क्रॉस ऑब्जेक्शन रेज कर सकता है, सो द पॉइंट्स ऑफ B एंड A बोथ विल बी हर्ड, बट फिर भी दे both go in appeal. So A had also appealed, B also appealed. Both the appeals were decided. अब मान लो इसमें से कोई एक अपील किसी टेक्निकल ग्राउंड पर डिसमिस हो जाता है, तो क्या वो डिसमिसल B के अपील पर भी रेस जुडिकाटा लगाएगा, मतलब दूसरे अपील पर रेस जुडिकाटा लगाएगा? वो लगाता अगर दोनों के सूट आइडेंटिटी अलग होते, बट हियर द आइडेंटिटी ऑफ द सूट इज सेम, दे बोथ अरोज फ्रॉम अ सिंगल सूट. Here they both arose from a single suit. So Nahari versus Shankar is the case on the point that if there is a single suit and from there are two or more appeals, then one of them is dismissed on technical grounds. So it cannot be said to be a former suit decided, and therefore the res judicata will not apply upon the other appeal. But the facts of the present case are different. Here you have got four distinct suits, and from that four distinct appeal, तो पढ़ लेते हैं इसको. An appeal was taken against one of the decrees. In those circumstances, this court held that there was only one suit. It was not necessary to file two separate appeals, and the fact that one of the appeals was time barred did not affect the maintainability of the other appeal, and the question of res judicata did not all arise. In the present case, there were two different suits from which different appeals had to be filed. In the present case, there were different suits from which different appeals had to be filed. So that is the difference in the fact. Nahari versus Shankar में single suit था, but यहाँ पर there are many suits. Different appeals had to be filed. The High Court's decision in the two appeals arising from the suit number 77 and 91 was undoubtedly earlier, and therefore the condition that there should have been a decision in the former suit to give rise to res judicata in a subsequent suit was satisfied in the present case. The contention that there was no former suit in the present case must therefore fail. ठीक, तो फॉर्मर सूट पे तो लिखवा ही दिया, अब थोड़ा सा नरहरि वर्सेस शंकर पे भी लिख लो, उसी पॉइंट पे जो पहला पॉइंट था आपका उसी में। तो पहले पॉइंट में एक और पैराग्राफ लिखिए आप, राइट इन नेक्स्ट पैराग्राफ in that point only. All right. The Supreme Court distinguished the facts in Narari versus Shankar 1950 Supreme Court with the facts of the present case and held that Narari versus Shankar would not apply to the present case, as in that case the various appeals had arisen out of the same single suit. In that case, if there is a single suit and both the parties are aggrieved, then also there is no need to file as many number of appeals. Even if one of the party go in appeals, the other party can raise his ground in cross objection in the said appeal. But if the parties so desire, they can file their own respective appeals. If one of the appeal is decided or dismissed on technical grounds, it cannot be said to be a former suit, heard and decided, as the appeal did not have a distinct identity. ठीक, तो ये पहला इशू खत्म हो गया। अब जो नेक्स्ट आपका इशू है दैट इज सेकंड इशू। अब ये फर्स्ट इशू तो आपका खत्म हो गया, लिखवा दिया मैंने। Now the second issue was as to whether the former appeals which has been dismissed on technical grounds can be said to have been heard and finally decided. तो आप second issue लिखिए, whether with respect to the appeals which have been dismissed on the technical grounds, it can be said that it was heard and finally decided. ठीक, क्योंकि एक्चुअली डिसमिसल तो टेक्निकल ग्राउंड पे हुआ, तो क्या उसको हर्ड एंड फाइनली डिसाइडेड माना जाएगा। अब इसको मैं समझाता हूँ। अब देखो, व्हाट हैपेंस इज देयर वाज अ सूट बिटवीन ए एंड बी, and there was suit between A and B, and there was another suit between A and B. तो दो सूट्स हैं मान लो, तो ये जो सूट्स हैं वो डिसाइड हो गए। दोनों सूट्स डिसाइड होने के बाद ए गोज इन अपील अगेंस्ट बोथ द सूट्स। अब एक अपील ए ने फाइल किया ए वर्सेस बी, एक और अपील उसने फाइल किया ए वर्सेस बी। सो टू अपील्स हैव बीन फाइल्ड। अब ये जो अपील है, सपोज दैट वन इज डिसमिस्ड ऑन सम टेक्निकल ग्राउंड्स। If the appeal is dismissed on merits on technical ground, so what is the main effect? That the trial court judgment becomes final. क्योंकि आपका अगर अपील डिसमिस हो गया तो ट्रायल कोर्ट का जजमेंट फाइनल हो जाएगा। ये अपील अगर आपका डिसमिस हो गया टेक्निकल ग्राउंड पर, अगर डिसमिस हो गया बार ऑफ लिमिटेशन और व्हाटएवर, तो ये जो डिक्री पास हुई थी यहाँ पर नीचे वाले कोर्ट में, तो दैट डिक्री बिकम्स फाइनल। अब दिस डिक्री विल अप्लाई एज रेस जुडिकाटा, क्योंकि एक बार जब डिक्री फाइनल हो गई इट विल अप्लाई एज रेस जुडिकाटा। अब नाउ इफ यू सी द अदर अपील इज ओपन and you conduct the hearing on that, then it may happen that there is conflict of decrees. अब सपोज अपलेट कोर्ट ने कुछ और डिसाइड कर दिया, अपलेट कोर्ट डिसाइड द अनदर अपील एंड इट डिसाइड्स डिफरेंटली, और जबकि ट्रायल कोर्ट का ये वाला डिक्री डिसमिसल की वजह से फाइनल हो गया। अब ये जो डिक्री था ए वर्सेस बी का सेकंड वाला, उसमें अगर अपलेट कोर्ट ने अपील की सुनवाई की, इफ द अपलेट कोर्ट कंडक्ट्स द हियरिंग ऑन अपील, इट मे गो फॉर सम पर्टिकुलर फाइंडिंग, एंड हियर बिकॉज ऑफ टेक्निकल डिसमिसल, ये जो पहले वाला सूट था उसमें there is a finality of the trial court decree. So there may be a conflict of judgments because of that. So first of all there may be a conflict of judgment. और दूसरा ये जब पहला वाले डिक्री फाइनल हो गया, रेस जुडिकाटा हो गया, so it is binding. And once it is binding, then how can you have a trial conducted in a appeal? So that is the main logic which the Supreme Court say, in this case says that once the appeal is dismissed on technical grounds, then also the trial court judgment becomes final. Once you file appeal, it becomes res sub judice. Now the appeal is dismissed. The document is this one, and it becomes res judicata, and that makes it final. There are two decrees. In this example, there are two decrees, and in both of them have the same matters in issue. अब उसी मैटर पर एक जजमेंट फाइनल हो गया और एक जजमेंट आप ओपन रखती हो, तो फिर वो लीगल अनसर्टेनिटी है वो दैट इज क्रिएटेड. सो ऑन दोज ग्राउंड्स द कोर्ट वाज हेल्ड. इफ वंस अ टेक्निकल डिसमिसल इज डन, तो ट्रायल कोर्ट का जजमेंट फाइनल हो गया. और ट्रायल कोर्ट का जजमेंट मेरिट्स पे था, ये ध्यान रखना. ट्रायल कोर्ट का जजमेंट टेक्निकल ग्राउंड्स पे नहीं था. ट्रायल कोर्ट का जजमेंट वाज ऑन मेरिट्स हियरिंग करने के बाद. लेकिन उसी टेक्निकल ग्राउंड पे होता, then that would be a different situation. But here in this case, the trial court decided the case on merits after hearing both the parties. So the technical dismissal of the appeal will result into a finality of the trial court judgment, which was passed on merits after hearing of the parties. So what becomes final is something which was actually heard and decided by the trial court. What becomes final after the dismissal is something which was heard and finally decided by the trial court. And once it has been heard and finally decided, then obviously other appeal पर उसका रेस जुडिकाटा लगेगा. ठीक, इसको ठीक से समझिएगा, इस पर कई बार सवाल आ चुके हैं, दिल्ली में पूछा है इन्होंने. ठीक, तो फिर से देखिए इसको. दिस इज अपील 1 एंड दिस इज अपील 2. दिस इज अपील पेंडिंग एंड दिस इज द अपील डिसमिस्ड ऑन टेक्निकल ग्राउंड. अब जैसे ही ये डिसमिस होगा, तो जो ट्रायल कोर्ट का सूट था डिक्री 1 इन द ट्रायल कोर्ट, दैट डिक्री बिकम्स फाइनल. जैसे ही डिसमिस होगा अपील, ट्रायल कोर्ट की डिक्री विल बिकम फाइनल. और ट्रायल कोर्ट की जो डिक्री है, एक बार वो फाइनल हो गई, तो ट्रायल कोर्ट की डिक्री वाज नॉट ऑन टेक्निकल ग्राउंड, दैट वाज हर्ड एंड फाइनली डिसाइडेड on merits. So means what becomes final? A decree which was made by the trial court after heard and final decided by the suit, having the heard and final decided the suit. Okay. So the dismissal of the appeal ultimately results into a decree becoming a final which was actually heard and finally decided. तो अब जो फाइनल है दैट इज हर्ड एंड फाइनल डिसाइडेड, और अपील को फॉर्मर सूट तो मान ही चुके हैं. अब जो सेकंड पेंडिंग अपील है, उसमें हर्ड एंड फाइनल डिसाइडेड वाला जो ट्रायल कोर्ट का डिक्री है, दैट विल बार एज रेस जुडिकाटा. अब इसको आप पहले लिख लो थोड़ा सा. सो राइट, द सुप्रीम कोर्ट हेल्ड दैट द डिसमिसल ऑफ एन अपील on a technical ground would result into a finality of the trial court's judgments, which was passed on merits. Let's stop. Next sentence. Even if the appellate court did not conduct any hearing on merits, and therefore in reference to the appellate court, it can be said that the decision of dismissal, said that the decision was not heard and finally decided, but the trial court's judgment, which ultimately becomes final, was actually heard and finally decided on merits. And therefore, it cannot be said that simply because the appellate court dismisses the appeal on the technical ground, the appellate court has not heard and finally decided the suit, as the trial court judgment having becoming as the trial court judgment have becoming final was actually heard and finally decided. As the trial court judgment having become final was actually heard and finally decided. ठीक, अब इसमें एक पैराग्राफ और आएगा कि इसमें ट्रायल कोर्ट का जजमेंट फाइनल होगा कि नहीं, बिकॉज ट्रायल कोर्ट का जजमेंट तो हर्ड एंड फाइनल डिसाइडेड था, दैट वाज ऑन मेरिट्स। अब वो भी अगर टेक्निकल ग्राउंड पर डिसमिस हुआ था, दैट वाज अ डिफरेंट केस, बट हियर इट वाज ऑन मेरिट्स। ट्रायल कोर्ट का जजमेंट वाज ऑन मेरिट्स, तो अपलेट कोर्ट ने अगर टेक्निकल ग्राउंड पर डिसमिस भी किया है तो फाइनल क्या हो गया? ट्रायल कोर्ट जजमेंट, and that was on merits. And now the situation is there is another appeal pending, and one of the appeal is decided, was actually decided but dismissed, but the dismissal का result के वजह से the trial court judgment become final. तो trial court का judgment final हो गया, मतलब it was heard and finally decided by the trial court. तो ये heard and final decided है एक मैटर पे, और उसी मैटर पे एक अपील पेंडिंग है. So will it not apply as res judicata on the pending appeal? ठीक, तो इसको नेक्स्ट पैराग्राफ में लिखिए. राइट, नेक्स्ट पैराग्राफ. द रिक्वायरमेंट ऑफ फॉर्मर सूट एंड ऑल्सो हर्ड एंड फाइनली डिसाइडेड हैविंग बीन फुलफिल्ड with respect to the appeal dismissed, it will apply as res judicata upon the other pending appeal. It will apply as res judicata upon the other pending appeal. It will apply as res judicata upon the other pending appeal. ठीक, ठीक. Now let's see the another paragraph, this paragraph of judgment. This brings us to the main point that has been urged in these appeals, namely that the High Court had not heard and finally decided the appeals rising out of suits number 77 and 91. One of the appeals was dismissed on the ground that it was filed beyond the period of limitation, while the other appeal was dismissed on the ground that the appellant therein had not taken steps to print the records. So they are just repeating that. Then it is therefore urged that the two appeals arising out of suit number 77 and 91 had not been heard and finally decided by the High Court, and so the condition that the former suit must have been heard and finally decided was not satisfied in the present case. So that is the logical contention. वो technical ground पर dismissal है, so obviously that cannot be said to be heard and finally decided. So that was the contention. That was the contention before the Supreme Court, and it was not the contention before High Court. Reliance in this connection is placed on the well-settled principle that in order that a matter may be said to have been heard and finally decided, the decision in the former suit must have been on merits. अब हर्ड एंड फाइनल डिसाइडेड का तो यही मतलब हुआ, आपने दोनों पार्टीज के एविडेंसेस लिए और उस पर डिसीजन दिया. अब वेयर फॉर एग्जाम्पल द फॉर्मर सूट वाज डिसमिस्ड बाय द ट्रायल कोर्ट फॉर द वांट ऑफ ज्यूरिडिक्शन. वेयर फॉर एग्जाम्पल द फॉर्मर सूट वाज डिसमिस्ड बाय द ट्रायल कोर्ट फॉर द वांट ऑफ ज्यूरिडिक्शन. अब ये कुछ आपको एग्जाम्पल्स बता रहे हैं टेक्निकल ग्राउंड्स कि किस ग्राउंड पर डिसमिसल हो सकता है. और फॉर डिफॉल्ट ऑफ प्लेंटिव्स अपीयरेंस, और ऑन द ग्राउंड ऑफ नॉन जेंडर ऑफ पार्टीज, और मिसजेंडर ऑफ पार्टीज, और मल्टी फेयरनेस, और ऑन द ग्राउंड दैट द suit was badly framed, or on the ground of a technical mistake, or for failure on the part of the plaintiff to produce probate or letters of the administration or succession certificate when the same is required by the law to entitle the plaintiff to a decree, or for the failure to furnish security for cost, or on the ground of improper valuation, or for failure to pay additional court fees on a plaint which was undervalued, or for want of cause of action, or on the ground that it is premature and the dismissal is confirmed in appeal, if any. तो मतलब ये सब ग्राउंड्स हैं, टेक्निकल ग्राउंड्स, जिस पर आप डिसमिसल कर सकते हो. तो ये कह रहे हैं कि अगर सूट को अगर इन ग्राउंड्स पर डिसमिस किया गया हो, इन टेक्निकल ग्राउंड्स पर, और फिर उसके बाद अपील में अपलेट कोर्ट ने भी उसको अप्रूव कर दिया होता, सो दैट इज व्हाट दे आर सेइंग, दैट इट इज प्रीमेच्योर एंड द डिसमिसल इज confirmed in appeal if any, the decision not being on merits would not be res judicata in a subsequent suit. The decision not being on merits would not be res judicata in a subsequent suit. तो अगर ट्रायल कोर्ट में जजमेंट वाज नॉट ऑन मेरिट्स, तो फिर अपील में ट्रायल कोर्ट के जजमेंट को अगर अपहोल्ड कर दिया गया या फिर टेक्निकल ग्राउंड पर डिसमिस कर दिया, तो व्हाट दे आर सेइंग इज कि ट्रायल कोर्ट का जजमेंट रेस जुडिकाटा नहीं लगाएगा, बिकॉज इट वाज नॉट हर्ड ऑन मेरिट्स। ठीक, बिकॉज इट वाज नॉट हर्ड ऑन मेरिट्स। ठीक, बिकॉज ट्रायल कोर्ट में हियरिंग ऑन मेरिट्स जरूरी है। अब हमारे केस में क्या है, अपलेट कोर्ट ने टेक्निकल ग्राउंड पर डिसमिस किया, लेकिन ट्रायल कोर्ट जजमेंट इज ऑन मेरिट्स, so after dismissal it becomes the final, trial court judgment becomes the final, and therefore it would be said that it is heard and finally decided. But none of these considerations apply in the present case, for additional civil judge decided all the four suits on the merits and decided the issue as to the title on merits against the appellant and his father. It is true that the High Court dismissed the appeals arising out of the suits number 77 and 91, either on the ground that it was barred by limitation or on the ground that the step has not been taken for printing the records. Even so, the fact remains. तो टेक्निकल ग्राउंड्स है डिसमिसल ऑफ अपील का, फिर भी कह रहे हैं इवन सो द फैक्ट रिमेन्स दैट द रिजल्ट ऑफ द डिसमिसल ऑफ द two appeals arising out of suit number so and so by the High Court on these grounds was what? That the trial court judgment become final. On these grounds was that the decrees of the additional civil judge who decided the issue as to the title on merits stood confirmed by the order of the High Court. तो अगर हाई कोर्ट का अपील में अगर डिसमिसल हुआ है, हाई कोर्ट में अगर अपील का डिसमिसल हुआ है और अगर टेक्निकल ग्राउंड्स पे भी हुआ है, तो ट्रायल का कोर्ट का जजमेंट जो कि मेरिट्स पे था, दैट स्टूड confirmed. Then in such a case, even though the order of the High Court may itself not be on the merit, the result of the High Court's decision is to confirm the decision on the issue of title which had been given on the merits by additional civil judge, and thus in effect the High Court confirmed the decree of the trial court on merits, whatever may be the reason for the dismissal of appeals. तो हाई कोर्ट ने अगर डिसमिसल किया है टेक्निकल ग्राउंड्स पे, लेकिन जो ट्रायल कोर्ट का जजमेंट जो मेरिट्स पे था, then that becomes final. In these circumstances, though the order of the High Court itself may not be on merits, the decision of the High Court dismissing the appeal arising out of suit number so and so was to uphold the decision of the merits as to issue of title, and therefore it must be held that by dismissing the appeals arising out of suit number 77 and 91, the High Court heard and finally decided the matter, for it confirmed the judgment of the trial court on the issue of title arising between the parties, and the decision of the trial court being on the merits, the High Court's decision confirming that decision must also be deemed to be on merits. तो जो हाई कोर्ट ने जो टेक्निकल ग्राउंड पर डिसमिस किया है, वो माना जाएगा कि हाई कोर्ट ने ट्रायल कोर्ट के जजमेंट को अपहोल्ड कर दिया है। तो इस डिसमिसल का मतलब है कि दैट जजमेंट बिकम्स फाइनल। तो एक बार जब वो जजमेंट फाइनल हो गया, तो दैट वाज ऑन मेरिट्स, सिंस दैट वाज ऑन मेरिट्स, तो माना जाएगा कि हाई कोर्ट ने ट्रायल कोर्ट के जजमेंट को मेरिट्स पे अप्रूव किया, मतलब हाई कोर्ट ने उस अपील को फाइनली हर्ड एंड डिसाइड किया, because ultimately what happening is the trial court judgment become final and that was on merits. Now to hold otherwise, अब कोर्ट काउंटर कंटेंशन की बात कर रहा है कि इसका उल्टा अगर होल्ड करेंगे तो क्या होगा। कोर्ट काउंटर कंटेंशन की बात कर रहा है, इसका उल्टा अगर होल्ड करेंगे तो क्या होगा। टू होल्ड अदरवाइज वुड मेक रेस judicata impossible in cases where the trial court decides the matter on merits. To hold otherwise would make res judicata impossible in cases where the trial court decides the matter on merits, but the appellate court dismisses the appeal on some preliminary ground, thus confirming the decision of the trial court on the merits. It is well settled that where a decree on the merits is appealed from, the decision of the trial court loses its character of finality, and what was once res judicata again becomes res sub judice, and it is the decree of the appellate court which will then be res judicata. But if the contention of the appellant were to be were, were to be accepted, and it is held that if the appeal court dismisses the appeal on the preliminary ground, like limitation or default in printing, thus confirming into the trials court decision giving on merits, the appellate court decree cannot be res judicata. The result would be that even though the decision of the trial court given on the merits is confirmed by the dismissal of the appeal on a preliminary ground, there can never be res judicata. There can never be res judicata. तो ये कह रहे हैं कि जो अपलेट कोर्ट का जो डिसीजन है, दैट डिसमिसल का डिसीजन, दैट डिसमिसल ऑर्डर ऑफ द अपलेट कोर्ट, दैट रिजल्ट्स इनटू व्हाट, दैट रिजल्ट्स इनटू द ट्रायल कोर्ट का जजमेंट का फाइनलिटी। तो अब हम अगर अपलेट का कंटेंशन अगर माने तो टेक्निकल डिसमिसल शुड नॉट अमाउंट टू रेस जूडिकाटा। अपलेट कोर्ट ने टेक्निकल ग्राउंड पर डिसमिसल किया, दैट शुड नॉट अमाउंट इन रेस जूडिकाटा। लेकिन लेट इफेक्ट क्या है कि ट्रायल कोर्ट का जजमेंट फाइनल हो गया एंड दैट वाज ऑन मेरिट्स। तो ट्रायल कोर्ट का जजमेंट रेस जूडिकाटा लगा रहा है, लेकिन अपलेट कोर्ट का जजमेंट यू आर सेइंग दैट इट इज नॉट अप्लाइंग रेस जूडिकाटा, देन हाउ इट इज पॉसिबल कि अपलेट कोर्ट ने जो डिसाइड किया दैट विल नॉट अप्लाई एज रेस जूडिकाटा, whereas the trial court का judgment becomes res judicata. That is not possible. So that is what they are saying कि ये दो conflicting चीज़ें हो जाएंगी कि अपलेट कोर्ट का जजमेंट फाइनल नहीं है बिकॉज दैट इज़ ऑन टेक्निकल ग्राउंड्स, लेकिन हाँ ट्रायल कोर्ट का जजमेंट जो है वो फाइनल हो गया। सो हाउ कैन इट बी पॉसिबल कि अपलेट कोर्ट और ट्रायल कोर्ट को आप अलग अलग देखो, बिकॉज अल्टीमेटली द ट्रायल कोर्ट जजमेंट ऑन मेरिट्स बिकम final. We cannot therefore accept the contention that even though the trial court may have decided the matter on the merits, there can be no res judicata if the appellate court dismisses the appeal on a preliminary ground without going into merits, even though the result of the dismissal of the appeal by the appellate court is confirmation of the decision of the trial court given on the merits. Acceptance of such a proposition will mean that all the losing party has to do to destroy the effect of a decision given by the trial court on the merits is to file an appeal and let that appeal be dismissed on some preliminary ground, with the result that the decision given on merits also becomes useless as between the parties. अब क्या होगा, आपके सूट का डिग्री मेरे खिलाफ आ गई, ठीक। अब ट्रायल कोर्ट का जजमेंट फाइनल होगा, आफ्टर मेरिट डिग्री मेरे खिलाफ आ गई, अब ट्रायल कोर्ट का जजमेंट फाइनल होगा। अब मैंने क्या किया, अपील कर दिया, अपील करके मैंने अपील को क्या किया, टेक्निकल ग्राउंड पर डिसमिस करवा लिया, खुद ही डिफॉल्ट कर दिया, द अपील इज डिसमिस्ड। अब अगर हम कंटेंशन मान लेते हैं तो क्या होगा, अपलेट कोर्ट का जजमेंट फाइनल हो जाएगा बिकॉज इट वाज डिसमिस्ड ऑन द टेक्निकल ग्राउंड। अपील इज द अल्टीमेटली द ट्रायल कोर्ट का जजमेंट फाइनल है बिकॉज ऑफ द डिसमिसल। लेकिन अगर हम कंटेंशन मान लें तो अपलेट कोर्ट का जजमेंट फाइनल नहीं हुआ बिकॉज दैट इज ऑन टेक्निकल ग्राउंड एंड देयरफॉर द रेस जूडिकाटा विल नॉट अप्लाई। तो इस तरीके से तो हर केस में अगर पार्टी अपील करके डिसमिस करवा दे, then every time the judgment becomes open and it will not res judicata. So that contention cannot be accepted. So acceptance of such a proposition will mean that all the losing party has to do to destroy the effect of a decision given by the trial court on merits is to file an appeal and let that appeal be dismissed on some preliminary ground, with the result that the decision given on merits also becomes useless as a between the parties. तो जो ट्रायल कोर्ट का जजमेंट था वो भी यूजलेस हो जाएगा. We are therefore of opinion that where a decision is given on the merits by the trial court, we are therefore of the opinion where a decision is given on the merits by the trial court and the matter is taken in appeal and the appeal is dismissed on some preliminary ground like limitation or default in printing, it must be held that such dismissal, when it confirms the decision of the trial court on the merits, itself amounts to appeal being heard and finally decided on the merits, whatever may be the ground for dismissal of the appeal. So it must be held that such dismissal, when it confirms the decision of the trial court on merits, itself amounts to the appeal being heard and finally decided on merits, whatever may be the grounds for dismissal of the appeal. तो ट्रायल कोर्ट में जजमेंट हो गया, अपील में गए, अपील को टेक्निकल ग्राउंड पर डिसमिस कर दिया, फिर भी माना जाएगा एज इफ द अपीलेट कोर्ट हैज heard and finally decided, because what becomes final is the judgment of the trial court which was on merits. ठीक ठीक, तो आई होप सबको समझ में आ गया होगा. इसको बार बार पढ़िए, read it several times, do not take it very lightly. अब इसमें एक नेक्स्ट पैराग्राफ में लॉजिक लिख लीजिए. What the Supreme Court held, that what is the rationale. So right, the court has held that if simply because the appeal was dismissed on technical ground, it will be said that the dismissal of appeal will not apply as res judicata, then any party may file an appeal and get it dismissed on technical ground and thus convert the trial court judgment, which was res judicata, into res sub judice by getting the appeal dismissed on technical grounds. Now next paragraph, right? Practically what happens is the moment the appeal is dismissed on a technical ground, the trial court judgment becomes final, and since the trial court judgment is on merits, it will be said that a former suit was heard and finally decided. That decision will be attributed to the appellate court, as it is the appellate court dismissal only which converts the trial court decision into res judicata. ठीक ठीक, तो हो गया. अब इसके बाद जो पैराग्राफ है वो आप पढ़ लीजिएगा. अब एक और पॉइंट है which I want to discuss here. ये पॉइंट है एज अ क्वेश्चन मुझे आपको बताना है कि अगर कभी एग्जाम में सिंगल सूट वाला पॉइंट आ जाए, that there was a single suit and from that there were two appeals. So in that the Sheodan Singh judgment will not apply. It was Narhari versus Shankar which is apply. And in the Narhari versus Shankar में they are saying that इन दोनों अपील्स की आइडेंटिटी अलग नहीं होंगी क्योंकि ये दोनों एक ही सूट से अराइज हुआ है. ठीक, एंड देयरफॉर वहाँ पर रेस जुडिकाटा नहीं लगा होगा. So it cannot be said to be a former suit heard and finally decided. बट लेकिन अगर एक से ज़्यादा सूट्स इन्वॉल्व थे और उनमें से अपील हुआ है तो रेस जुडिकाटा लगेगा. अब डीजीएस वगैरह में क्या किया है, उन्होंने एक से ज़्यादा सूट वाला सवाल नहीं पूछा, उन्होंने सिंगल सूट वाला सवाल पूछा जो कि नरहरि वर्सेस शंकर से पूछा है. बट वो मल्टीपल सूट्स पे भी पूछ सकते हैं, तो आपको कॉशियस रहना पड़ेगा कि वो किस पर पूछ रहे हो. अब एक बात और ध्यान रखिएगा एज अ क्वेश्चन, कि सैदान सिंह में ऑल द अपील्स आर फाइल्ड बाय whom? बाय द सेम पर्सन। ऑल द अपील्स वर फाइल्ड बाय द सेम पर्सन। अब सैदान सिंह के फैक्ट्स को आप ध्यान रखिएगा, जब सेम फैक्ट्स हों तब सैदान सिंह लगेगा, अदरवाइज क्या होगा। आई जस्ट एक्सप्लेन टू यू। मान लो देयर वाज अ डिक्री बिटवीन ए एंड बी, और एक और सूट था, मान लो ए वर्सेस बी। अब इस डिक्री से ए ऑल्सो डिससेटिस्फाइड एंड बी ऑल्सो डिससेटिस्फाइड। इस डिक्री से ए भी सेटिस्फाइड नहीं है और बी भी सेटिस्फाइड नहीं है। अब ज़्यादा डिक्री ए के फेवर में, बी इज द एग्रीव्ड पार्टी। अब ए को भी मान लो सारा रिलीफ नहीं मिला, उसको कुछ पॉइंट पर डिससेटिस्फैक्शन है, तो ए भी अपील कर सकता है कि नहीं। ही विल गो इन टू द अपील फॉर हिज डिससेटिस्फैक्शन। सपोज ए क्लेम्स टू रिलीफ एंड ही ओनली गॉट वन, सो ए इज ऑल्सो एग्रीव्ड। और बी के खिलाफ रिलीफ है तो बी तो एग्रीव्ड होगा ही होगा। अब इट मे हैपन कि एक अपील कर दिया ए ने और एक अपील कर दिया बी ने। बहुत ध्यान से सुनिएगा आप इसको। ए ने अपनी ग्रीवेंस के लिए अपील कर दिया और बी ने अपने ग्रीवेंस के लिए अपील कर दिया, लेकिन ए का ग्रीवेंस है जो छोटा है। बी हैज गॉट द मेजर ग्रीवेंस फ्रॉम द डिक्री। अब ए ने क्या किया कि जानबूझकर अपना अपील डिसमिस करा लिया टेक्निकल ग्राउंड्स पे। अब ए के पास राइट टू अपील है, ए ने जानबूझकर अपना अपील टेक्निकल ग्राउंड पे डिसमिस करा लिया, क्योंकि उसको पता है कि मेरा नुकसान नहीं होगा, लेकिन कम से कम बी का अपील तो ख़त्म करा दूंगा। तो उसने जानबूझकर लिमिटेशन के बाद अपील फाइल किया। सो द अपील डिसमिस्ड ऑन द टेक्निकल ग्राउंड। ठीक। अब व्हेन यू से दैट द रेस जुडिकाटा अप्लाई ऑफ सैदान सिंह, इसे ये अपील डिसमिस हो गया, इट गॉट अ डिस्टिंक्ट आइडेंटिटी फ्रॉम वन सूट and therefore the former suit heard and finally decided on the logic of the Sedan Singh, and he gets the appeal dismissed, and therefore on that basis he claims कि बी के अपील पर res judicata लगना चाहिए। अब बताइए, would this be allowed? Should this be allowed? Would this be allowed or should this be disallowed? अब when you go by the Sedan Singh judgment that did not comes out, it would be totally unjust। जिस तरीके सैदान सिंह केस ने सुप्रीम कोर्ट ने बोला है इट मे बी मिसयूज्ड बाय अ पार्टी, अब उस तरीके से यहाँ पर भी तो मिसयूज होगा ये। अब एक पार्टी जिसके पास थोड़ा ग्रीवांस है, उसने जानबूझकर अपील फाइल करके और टेक्निकल ग्राउंड्स पे अपील को डिसमिस करा लिया, और बाद में कोर्ट में कह दिया कि इसका जो अपील है दैट इज बार्ड बाय रेस जुडिकाटा। सो दैट शुड ऑल्सो नॉट बी अलाउड, एंड देयरफॉर यू ऑलवेज कीप इन माइंड कि सैदान सिंह की जजमेंट के अनुसार इट शुड बी अलाउड, लेकिन द फैक्ट इज दैट इन सैदान सिंह ऑल द अपील्स वर मेड बाय द सेम पार्टी, एंड देयरफॉर यू शुड हैव रीड द सैदान सिंह जजमेंट इन अ नैरो लिमिटेड प्रोस्पेक्टिव। तो अगर फैक्ट्स बिल्कुल सेम है तो सैदान सिंह लगाना, लेकिन अगर फैक्ट्स सेम नहीं है, इस तरीके के हो गए, then you can always say that the Sedan Singh facts, case of Sedan Singh facts is distinguished with these facts, and in that all the appeals were filed by the same party in Sedan Singh, and here the appeal is filed by some opposite party, and the opposite party is trying to misuse the judgment, and the policy of the law is not to allow to misuse the judgment, and therefore the Sedan Singh judgment can be restricted to its own facts, and here this cannot be allowed, and res judicata should not apply। ठीक। तो किसी भी प्रोविज़न को आप एब्यूज़ नहीं कर सकते, किसी भी प्रोविज़न ऑफ लॉ को आप एब्यूज़ नहीं कर सकते। नो पार्टी कैन अब्यूज़, क्योंकि सेक्शन 151 में कोर्ट के पास हमेशा पावर है किसी भी अब्यूज़ ऑफ प्रोसेस को रेस्ट्रिक्ट करने के लिए ऑर्डर्स पास कर सकती है। तो द कोर्ट कैन, डिस्पाइट the fact res judicata that seems to be applicable here, the court can under section 151 res judicata will not apply. The court can declare under 151 that the res judicata will not apply, also on the grounds that the facts of the Sedan Singh case is different from the facts of this case। तो इसको भी आप लिख लो, right? The Sedan Singh judgment has to be limited to his own facts. Therein all the appeals are filed by the same party। therein all the appeals were filed by the same party. If in a case, if in a case both the opposite parties, were aggrieved and one of them filed an appeal and got it dismissed on a technical ground, then the res judicata of that dismissal should not apply upon the appeal filed by the opposite party. Next sentence. That would amount to injustice to the opposite party and also an abuse of process. It will also amount to the misuse of sheodan Singh judgment, and therefore the court can distinguish the fact of such case with the facts of sheodan Singh and refuse to apply res judicata. The court has such power even under section 151 of CPC. Even under section 151 CPC. The court has such power even under 151 CPC. अब सैदान सिंह से मिलता जुलता एक और जजमेंट आप लिख लीजिए. दैट इज बजरंग लाल शिवचंद्राई रुइया वर्सेस शशिकांत एन रुइया. दैट इज 2004 सुप्रीम कोर्ट. ये 3 जजेस बेंच थी, जबकि सैदान सिंह केस में दैट इज 4 जजेस बेंच. सो दैट वाज द लैंडमार्क जजमेंट. इट वाज 4 जजेस बेंच. अब एक और केस लिखो. दैट इज मैनेजिंग डायरेक्टर एंड अदर्स वर्सेस के रामचंद्र नायडू. दैट इज 1994 सुप्रीम कोर्ट. ये आपका नरहरि वर्सेस शंकर से मिलता जुलता केस है. नरहरि वर्सेस शंकर, जिसमें सिंगल सूट पे मल्टीपल अपील्स. तो सिमिलर फैक्ट्स पे दैट वाज हियर आल्सो. तो केस का नाम याद रखिएगा. ठीक. तो बाय दिस इसमें कुछ थ्योरेटिकल चीज रह गई है रेस जुडिकाटा में, इस टॉपिक में. तो ये केस तो खत्म हो गया, पर जो टॉपिक रेस जुडिकाटा हम कंटिन्यू कर रहे हैं उसमें कुछ थ्योरेटिकल चीज रह गई है, तो उसके बाद रेस जुडिकाटा आपका खत्म हो जाएगा. बट दैट वी कंटिन्यू इन द नेक्स्ट लेक्चर, and in the next lecture we would get over with the res judicata and start with the another topic. That's it for this lecture. Thank you for watching lecture.